My family runs the city. You work for me.
The scene was the familiar, slightly fluorescent-lit stage of syndicated television justice, yet something fundamental, something cold and irreconcilable was about to fracture the carefully maintained decorum. Judge Joseph Wapner, the unchallenged titan of the People's Court, a figure revered for his stern yet fundamentally equitable application of common sense and civil code, was presiding over what appeared to be a standard low-stakes civil disagreement, a mundane quarrel over a broken piece of equipment, perhaps some minor debt, the kind of case that defined the show's daily diet of human friction. But this particular afternoon, this seemingly routine matter was poised to detonate an emotional charge that would strip away the veneer of television performance and reveal a raw, almost punitive judicial anger rarely witnessed on air, triggered by a single casually delivered sentence of breathtaking, self-aggrandizing entitlement.
This was not merely a moment of professional irritation. It was a seismic ethical shockwave felt across the courtroom, a cold judgment delivered with an intensity that suggested not just a legal defeat for the defendant, but a profound moral repudiation. The gravity of the confrontation was amplified by Wapner's reputation. He was known for his judicial temperament, a fusion of impatience with frivolousness and profound respect for the law. When Wapner became icy, it meant the line between civil dispute and contemptible arrogance had been utterly obliterated. The resulting ruling was not just adverse, it was annihilating, a career-defining moment of judicial severity rooted entirely in the arrogance encapsulated by 4 words directed at the court itself: "You work for my family." To understand the sheer magnitude of this judicial recoil, one must first appreciate the context of the People's Court during its original run.
It was the 1980s, an era defined by a blend of burgeoning consumerism and a lingering faith in institutional authority. Wapner served as the ultimate accessible arbiter, transforming the dense, often alienating world of small claims court into digestible, daily drama. His courtroom was a stage for ordinary Americans to settle scores, usually over damaged goods, rent deposits, or minor vehicular incidents. The stakes were small, often capped at a few $1,000s, but the drama was real, fueled by wounded pride and deep-seated grudges. The process was designed to be democratic, a level playing field where a janitor's claim held the same weight as a lawyer's defense. This fundamental equality was the bedrock upon which Wapner built his legacy. The conflict brought before him on this pivotal day involved a plaintiff, Mr. Robert Jenkins, names modified for privacy, though the details of the case remain historically consistent. A small-time mechanic specializing in custom vehicle detailing and modifications. Jenkins, a man whose hands were permanently stained with grease and whose demeanor suggested years of honest, grinding labor, was suing for payment for services rendered and materials used on a high-end luxury vehicle. The amount in dispute was substantial for a small claims case, nearing the maximum recoverable limit, indicating a significant project gone sour. Jenkins stood before the bench, visibly nervous but resolute, presenting invoices and photographs detailing meticulous work that had gone unpaid. The defendant, identified only as Mr. Maxwell, presented a stark contrast. Maxwell was impeccably dressed, radiating the smooth, effortless confidence of inherited wealth and unquestioned social standing. He was young, perhaps in his early 30s, and approached the proceedings not with the humility expected of a litigant, but with an almost bored detachment. Maxwell was not denying that the work had been done. Rather, he was asserting that the work was somehow deficient, justifying his refusal to pay. But the manner in which he articulated this defense was laced with an insidious condescension, suggesting that Jenkins's services were inherently inferior simply because of Jenkins's lower social status. The core legal conflict initially revolved around quality of workmanship. Jenkins argued that Maxwell had approved the modifications, and then, after taking possession of the vehicle and enjoying its use for several weeks, had suddenly manufactured arbitrary defects to avoid the final invoice. Maxwell countered by claiming the paint finish was imperfect and that the engine tuning lacked the elite performance standard he expected. The typical back and forth commenced, Jenkins presenting receipts for specialized components, Maxwell dismissing them as cheap or poorly installed. Wapner listened intently, leaning forward over the bench, his glasses resting low on his nose. He began his standard pattern interrupt, interjecting detailed questions about the contractual agreement, the timeline, and the specific metrics of the alleged deficiencies. He quickly deduced that the technical claims of poor workmanship were thin. The primary issue was clearly a sophisticated, perhaps deliberate, attempt at contractual avoidance. It seemed Maxwell believed that by delaying and obfuscating, Jenkins, being a small businessman, would eventually capitulate and drop the lawsuit rather than pursue the matter further. The deeper, more troubling issue, however, was the palpable air of contempt that Maxwell displayed not just towards Jenkins, but towards the entire judicial process. His answers were often vague, punctuated by sighs of exasperation, as if the requirement to explain himself to a court of law was beneath his dignity. He kept referencing the vastness of his family's enterprise, the prominence of their name in the regional business landscape, and the expectation that vendors should simply be grateful for the opportunity to work for them, regardless of payment schedules. This subtle arrogance began to weave an open loop of curiosity. Who was this family? What enterprise warranted such extreme, casual dismissal of standard legal procedure? Wapner, a man who had seen thousands of small-time bullies and minor fraudsters, recognized the pattern of privilege weaponized against diligence. Jenkins, sensing the court's skepticism, pressed his case with renewed vigor, detailing the financial strain the non-payment had caused. He explained that he had taken out a short-term business loan to cover the cost of the specialty parts that were now effectively sitting unpaid for in Maxwell's garage. He spoke of sleepless nights and the potential layoff of his single employee if the debt remained unresolved. His desperation was genuine, a plea for basic economic justice. Maxwell's response to this financial anguish was the first major escalation. Instead of addressing the facts of the loan or the work performed, he smiled slightly, a gesture of profound patronization, and casually remarked that Jenkins should simply find better clients, he implied, who operated in the same stratosphere as his own family. This blatant dismissal of the plaintiff's livelihood, based purely on perceived class difference, caused a visible tightening around Wapner's mouth. The judge reminded Maxwell curtly that class standing had no bearing on contract law and demanded he stick to the evidence. The tension climbed steadily. Wapner continued to probe the quality of workmanship claims, quickly exposing them as superficial excuses. When pressed to provide specific, verifiable evidence, expert witness reports, independent appraisals, Maxwell faltered, unable to produce anything concrete. He resorted to generalizations, claiming that anyone who was anyone in the city knew his family's reputation and knew that when they commissioned work, they expected the highest, most unparalleled standard. This fixation on reputation rather than legal substance signaled his underlying strategy: leverage social power to intimidate the court. The case was developing into a classic struggle of David versus Goliath, but with the added layer of class warfare being played out on a public stage. The audience, usually reactive with whispers and gasps, seemed unusually subdued, sensing the heavy, escalating stakes. This wasn't just $5,000 anymore. It was about the sanctity of contract and the notion that the law applied equally to the heir and the hourly worker. Wapner, leaning back slightly, delivered a crucial re-engagement hook. He interrupted Maxwell's rambling justification of his family's prominence and sternly focused the proceedings. Mr. Maxwell, this court is concerned with contractual obligations, not your social pedigree. You have failed to prove deficiency. The plaintiff has provided detailed invoices and evidence of performance. Why, specifically, should this court excuse you from this financial obligation? Maxwell, visibly annoyed that his non-legal influence wasn't swaying the judge, sighed dramatically, looking around the courtroom as if appealing to a jury of his social peers. He leaned into the microphone, his tone shifting from bored detachment to outright, cold assertion. He believed, fundamentally, that Wapner was operating under a different set of rules that acknowledged his family's superior position. Then came the definitive moment, the precise catalyst that shattered the judge's patience and triggered the legendary cold ruling. In a final, desperate attempt to assert dominance and dismiss the judge's authority, Maxwell delivered the line that cemented this case's place in courtroom history, a sentence dripped in the toxic belief that institutional figures, even those on television, were merely extensions of his family's corporate infrastructure. "Judge," Maxwell stated, his voice ringing with chilling certainty, his eyes wide with a combination of defiance and genuine confusion as to why Wapner wasn't simply folding. "You don't seem to understand the hierarchy here. My family owns major stakes in the studios that produce this kind of programming. We have connections everywhere. Frankly, you work for my family, indirectly or otherwise."
This small claim is irrelevant to people like us, and I find it insulting that I have to stand here and justify myself to a minor court official who is ultimately employed by the structures we control. The silence that followed was instant and absolute, a sudden vacuum of sound so profound it seemed to pull the oxygen from the air. The bailiff froze. The court reporter stopped typing. Wapner, who had been leaning slightly forward, abruptly straightened up, becoming preternaturally still. All residual humor, all trace of the showman's energy that typically defined his television presence, evaporated instantly. The transformation was terrifying. Judge Wapner's face went pale, the familiar, often ruddy complexion draining away, leaving behind a stark, severe canvas of pure professional outrage. His eyes, fixed, unblinking on Maxwell, held a look that transcended mere anger. It was the chilling, calculated fury of an institutional pillar whose integrity had been catastrophically challenged. Maxwell had not only committed contempt of court by implying influence over the judicial process, he had committed the ultimate transgression in Wapner's courtroom, confusing financial power with legal authority and implying that the very scales of justice were for sale or rent to the highest bidder. The judge reached out slowly, deliberately picking up his gavel, not to strike it, but simply to hold it, balancing the symbol of judicial authority in his hand. He looked at Maxwell, not as a defendant, but as a moral stain on the judicial fabric. His voice, when it finally cut through the heavy silence, was low, measured, and stripped bare of all warmth. It was the sound of bedrock freezing over. "Mr.
"Maxwell," Wapner began, his voice dangerous in its quiet precision, "I believe we have reached the conclusion of your testimony, and I believe we have reached the conclusion of this case. You have just made a fundamental error in judgment regarding who exactly holds the authority in this room and precisely what my role entails. Be very clear, I do not work for your family. I work for the law, and the law is about to deliver a profound lesson on entitlement." This initial declaration, cold and absolute, was the immediate payoff. The defendant, previously smug, suddenly looked terrified, understanding in that instant that his attempt at intimidation had spectacularly backfired, inviting an unprecedented judicial wrath.
The full consequences of this monumental arrogance, the exact details of the final devastating judgment Wapner delivered, the calculated financial and legal destruction of Maxwell's flimsy defense, and the aftermath of a ruling that resonated far beyond the confines of the television studio are yet to unfold. We delve into the meticulous dismantling of Mr. Maxwell's case and the specific, chilling language of Judge Wapner's ruling in the next installment. The atmosphere within the televised courtroom of the People's Court had shifted irrevocably. What began as a mundane civil dispute, the kind of trivial squabble over property lines or unpaid services that defined the program's bread and butter, had quickly curdled into a palpable confrontation of class and conduct.
Judge Joseph Wapner, A figure renowned for his accessible judicial temperament, stern yet often imbued with a dry, pedagogical patience, was exhibiting a rare and disturbing tightness around his eyes, a sign recognized by the veteran crew as exceeding mere judicial annoyance. This was the precursor to a profound, chilling engagement, distinct from the hundreds of routine admonitionments he had delivered throughout his career. The specific mechanism of the dispute involved a seemingly insignificant sum, roughly $2,000, claimed by the plaintiff for specialized technical consultation work that the defendant adamantly refused to compensate. The plaintiff, an earnest, middle-aged professional whose demeanor suggested nervousness mixed with rigid adherence to documented facts, had provided detailed invoices and a meticulously maintained log of hours and deliverables. His presentation was textbook small claims procedure, clear, chronological, and supported by irrefutable paper evidence. The defendant, conversely, operated under an entirely different judicial paradigm. He was a man whose expensive, custom-tailored suit seemed to function less as a tire and more as a portable fortress, shielding him from the unpleasant realities of accountability. His defense was not based on counter-evidence or technical refutations of the plaintiff's claims. Rather, it was built upon a dismissive, unwavering assertion that the plaintiff's work was intrinsically beneath the necessary standard required by a person of his stature. He repeatedly referred to the services rendered as unnecessary frippery and the contract terms as easily dismissed formalities, implying that his reputation alone superseded any written agreement. This fundamental mismatch in methodologies, fact versus assumed authority, was the engine driving the escalating tension.
When Wapner attempted to guide the defendant back to the evidentiary requirements, pressing him to address the time-stamped emails and signed confirmations presented by the plaintiff, the defendant would pivot with sophisticated evasiveness. He didn't merely ignore the questions, he treated the judge's inquiries as procedural distractions, nuisances that temporarily obstructed his path to inevitable victory. Mr. Defendant's name withheld for journalistic convention, Wapner stated, his voice now lower and harder, penetrating the murmur of the gallery. I have reviewed Plaintiff's Exhibit B, which clearly shows your signature confirming receipt and initial satisfaction with the prototype delivered on the 10th of last month. Can you tell me why you suddenly claim this prototype was unsatisfactory 2 weeks after that confirmation? The defendant leaned back, a posture of deliberate, theatrical boredom. He sighed audibly, a sound captured perfectly by the overhead microphones, rich with condescension. Your Honor, with all due respect to the formalities of this venue, he began, using the word venue with a palpable sneer that separated the court from the serious, legitimate halls of justice he evidently frequented. The document merely confirms I received something. It does not confirm its quality. My standards, which are known throughout the industry, demand excellence. This work was, frankly, pedestrian. And to quibble over a date on a piece of office paper is beneath the dignity of this entire affair. The reference to dignity delivered by the litigant who was actively undermining the solemnity of the proceedings was a powerful, pattern-interrupting moment. Wapner, momentarily stunned by the sheer audacity of the reply, paused. It wasn't the disrespect itself that was so jarring. Wapner dealt with disrespect daily, but the context.
The defendant was not angry or desperate. He was merely inconvenienced by the necessity of acknowledging the judicial process. He believed his stature should grant him an automatic dispensation from the requirement of factual defense. This escalating pattern continued throughout the cross-examination. Each attempt by the judge to establish a legal foundation, the burden of proof, the sanctity of contract, the rules governing admissible testimony, was met with a smug counter-narrative of intrinsic superiority. The defendant seemed intent on arguing that the law itself was a fluid concept, easily bent or ignored by those possessing sufficient economic and social gravitational pull. The plaintiff, watching this exchange, grew increasingly pale. He had come prepared for a judicial review of facts, not a psychological battle against entrenched entitlement.
The subtext of the defendant's testimony was a constant, unspoken threat. Even if I lose this technical battle, my world is larger and more consequential than yours. The financial intricacies of the case were meticulously detailed, absorbing extensive time for an otherwise straightforward civil claim. Wapner insisted on dwelling on the specifics of the contract clauses, perhaps hoping to pin the defendant down with objective language. He inquired about a specific clause concerning intellectual property transfer, a provision often used to inflate the perceived value of the services rendered. Clause 4.1, Wapner articulated, adjusting his spectacles, clearly states that failure to provide written notification of dissatisfaction within 7 calendar days of final delivery constitutes acceptance of the deliverables and triggers the immediate obligation for the final payment installment. Mr.
Defendant, the plaintiff has shown documentation proving he delivered the final product 13 days before your first written complaint. That is 6 days outside the contractually agreed upon window. Here, the defendant deployed his most irritating tactic, patronizing explanation. Your Honor, with respect, he began, maintaining eye contact not with the judge, but slightly above his head, as if addressing an invisible higher authority. That clause, while technically present, is entirely boilerplate. It's designed for contractors working on small, independent projects. We are talking about my firm's reputation here. When a problem arises, a serious problem that affects the efficacy of future investments, the timeline becomes irrelevant. Do you truly expect me to adhere rigidly to a timeline when the fundamental quality of the work is compromised? My internal counsel advised me that, given the circumstances, the spirit of the agreement outweighs the letter of the clause.
This statement was a direct, contemptuous challenge to the authority of the court to interpret contract law. The spirit of the agreement rhetoric was a thinly veiled attempt to assert that the defendant's subjective dissatisfaction, regardless of factual timelines or signed stipulations, should always prevail. It implied that the judge's role was merely advisory, subservient to the defendant's perceived business necessity. It was at this precise moment, during this extended period of development and escalating defiance, that the internal temperature of the courtroom plummeted. Wapner, having endured the repeated dismissal of legal principles, procedural fairness, and the very structure of civil litigation, realized he was not presiding over a typical reality television dispute. He was witnessing a deliberate, calculated display of legal nihilism, where the law was merely an inconvenience to be navigated through social leverage.
The judge leaned forward, his massive desk suddenly seeming inadequate to contain his simmering frustration. He interrupted the defendant mid-sentence, cutting through a verbose explanation about market confidence and stakeholder responsibility. Mr. Defendant, Wapner stated, the sound devoid of his usual timbre of professoral correction, replaced instead by a cold, metallic sharpness. You have spent the last hour dismissing every piece of physical evidence presented by the plaintiff. You have dismissed the contractual timelines you agreed to, and now you are attempting to instruct this court on how we ought to interpret established contract law based on your subjective estimation of your own reputation. The defendant, used to dominating conversations, bristled slightly at the interruption.
He opened his mouth, prepared to launch another lengthy justification rooted in his business success, confident that his charm or wealth would ultimately bore the judge into submission. He failed to recognize the point of critical mass had been reached. Wapner continued, pressing the point relentlessly, demonstrating the methodical precision that had defined his decades on the bench. He detailed the specific precedents that governed the enforceability of time is of the essence clauses, drawing a stark contrast between common law standards and the defendant's self-serving interpretation. The development of the case shifted from arguing the facts of the landscaping service to arguing the fundamental validity of the judicial system itself. This protracted, detailed legal lecture served as the critical reenactment, a second hook designed to underline the severity of the situation.
Wapner was no longer simply adjudicating a $2,000 claim. He was defending the entire judicial philosophy that underpins American small claims courts. The idea that every contract, regardless of the signatory's net worth, holds equal weight under the law. The defendant, however, interpreted the judge's lecture as a weakness, a sign that Wapner was overcompensating for a lack of understanding regarding real-world business practices. He waited for a break in the judge's commentary, his face set in a mask of practiced indifference, ready to unleash the culmination of his contempt. The tension mounted excruciatingly. The entire exchange had become a slow-motion car crash, where every word pushed the litigants closer to the inevitable definitive collision. The case was moving into its final phase, requiring the defendant to present his last arguments regarding why the plaintiff should not be awarded the full judgment.
It was here, during this concluding opportunity for defense, after Wapner made a final, decisive ruling about the inadmissibility of a highly subjective financial affidavit presented by the defendant, a ruling that legally crippled the defendant's entire position, that the final, irrevocable dissent occurred. The ruling on the affidavit was the final pattern interrupt. It removed the defendant's last legitimate pretense for arguing subjective business standards. Stripped of his complex legal maneuvers, the defendant was left exposed, relying solely on his self-importance. Frustration, mixed with a lifetime expectation of immunity from inconvenience, finally boiled over. The judge had just declared his affidavit inadmissible, stating plainly, "Your opinion on your future profitability, Mr. Defendant, is not evidence of the plaintiff's contractual failure." It was an undeniable legal checkmate.
Cornered and furious that his assumed power had been negated by procedural rules, the defendant abandoned all pretense of legal decorum. He straightened his tie with a precise, aggressive movement, locking eyes with Judge Wapner. The air froze, heavy with the weight of the coming confrontation, leading directly to the ultimate, unforgivable statement that would trigger Wapner's most frigid judgment ever, a judgment rooted not just in contract law, but in the defense of the legal institution itself. The defendant, seeking to assert a perceived higher authority that he believed transcended the televised bench, prepared to deliver the line that suggested the judge was merely a temporary, replaceable impediment in the grand scheme of his powerful life. The words hovered unspoken, primed to redefine the limits of courtroom insolence. The statement hung suspended in the manufactured atmosphere of the studio courtroom, a physical pollutant of arrogance that defied the very principles upon which the American judiciary was ostensibly founded. It was not merely a casual insult or a frustrated outburst, both of which Judge Joseph Wapner had navigated countless times across his decades-long career, both on the municipal bench and in the nationally broadcast laboratory of the People's Court. Instead, the 8 words, "You work for my family," were a direct and unvarnished assertion of socioeconomic supremacy, an attempt to subordinate the judicial process itself to the defendant's perceived hierarchy of inherited wealth and influence. The ramifications of such a pronouncement, delivered within the sacred geometry of the courtroom, even a televised one, were seismic, striking at the foundational myth of equal justice under law.
Wapner, whose judicial demeanor was renowned for its blend of avuncular patience and uncompromising rigor, did not immediately erupt. His reaction was far more chilling than a sudden theatrical explosion of temper would have been. Instead, he simply ceased all movement. The rapid rhythm of the cross-examination, which moments before had been a sharp, almost percussive dialogue, driven by the urgency of the minor financial claim at hand, evaporated into a vacuum of silence. Wapner leaned back slightly, a movement so minimal it might have been missed by a casual viewer, yet in the context of the televised trial's rapid pace, it was the cessation of all forward momentum. He adjusted the spectacles resting upon his nose, a familiar tic that usually signaled preparation for a critical legal inquiry or the summing up of evidence, but this time the gesture appeared to be a mechanism for processing a severe trauma to institutional integrity.
The immediate visual contrast between the litigants underscored the enormity of the defendant's error. The plaintiff, whose claim centered on a relatively small sum for unpaid services or damaged property, the details of which had suddenly become utterly immaterial, stood frozen, visibly pale, eyes wide not just with shock at the defendant's brazenness, but perhaps with a sudden, sinking realization of the forces arrayed against them. The plaintiff was, by all appearances, an individual of modest means, relying entirely upon the supposed impartiality of the court to enforce a simple contract or settle a basic civil wrong. Their vulnerability, now starkly exposed by the defendant's proclamation of power, amplified the toxicity of the statement exponentially. If the plaintiff had hoped for a simple resolution, they now confronted a realization that their opponent viewed the entire judicial framework not as a neutral arbiter, but as a bureaucratic hurdle designed merely for the inconvenience of the wealthy, or worse, as an instrument already controlled by them. This perception of control was the very poison that Wapner was now mandated to neutralize. Judge Wapner understood that his response could not be merely punitive, it had to be pedagogical. It had to serve as an unequivocal reaffirmation of the judiciary's absolute independence, a lesson broadcast to millions that in his courtroom, wealth did not purchase immunity, nor did it confer the right to dictate terms to the bench. His slow absorption of the insult was a deliberate, calculated judicial pause, a moment where the weight of centuries of legal precedent settled upon the modern spectacle of daytime television justice. The defendant, likely emboldened by years of operating outside typical accountability and misinterpreting Wapner's silence as confusion or maybe even deference, made the critical error of attempting to elaborate, or perhaps simply failing to comprehend the depth of the precipice they had just approached. The journalistic accounts from observers present in the studio, the bailiff, the court personnel, and the few allowed audience members later concurred on this crucial detail. The defendant offered a slight, self-satisfied smirk, a fleeting expression of smug confirmation, as if the phrase had been a necessary clarification, reminding the judge of the true pecking order of the community. It was the final drop of oil poured onto the already overheating legal engine. Wapner's eyes, magnified slightly by his spectacles, narrowed. They held a gaze that observers often described as dissecting, a look that stripped away pretense and exposed the core motives of the person standing before him. He did not raise his voice. He did not bang his gavel. That immediate, theatrical gesture was too crude for the gravity of this transgression. Instead, his voice, when it finally emerged from the charged stillness, was low, measured, and dangerously deliberate, each syllable weighted with the authority not just of a single judge, but of the entire history of Anglo-American common law. He began not by addressing the defendant's behavior directly, but by referencing the implicit social contract the courtroom represented. He spoke briefly, yet profoundly, about the concept of judicial neutrality, citing in all but name the very symbol of Lady Justice, blindfolded precisely so that the face of the litigant, whether rich or poor, renowned or obscure, could not sway the scales. This was Wapner's re-engagement maneuver, reminding the audience and, more importantly, the defendant, that they were operating under rules established long before they amassed their wealth, rules that demanded respect regardless of their financial portfolio. He detailed the historical necessity of an independent judiciary, a necessity forged in resistance against monarchical and oligarchical control. The judicial robe he wore, he implied, was not merely a costume for television, but the uniform of an office established to prevent exactly the kind of coercion and assumed privilege the defendant was attempting to exercise. He meticulously deconstructed the implication of the phrase, "You work for my family," laying bare the societal threat it contained. It was an implication that, if accepted, would effectively dismantle the entire legal framework, transforming the public courts into mere extensions of private security services for the elite. Wapner articulated that the integrity of the court, and thus the legitimacy of his ruling, rested entirely upon the premise that his duty was to the law, codified statute, and the facts presented, not to the economic interests or political connections of any singular family. He emphasized that every taxpayer, every citizen, contributed to the funding of the court system, a system dedicated to ensuring that the person of limited resources and the person of immense means stood on exactly the same ground when presenting their case. The defendant's assertion was not just offensive, it was seditious to the spirit of American law. The judge then began to move toward the legal substance, but with a palpable shift in intent. While the initial dispute was about monetary damages, Wapner now transitioned the focus of the proceedings entirely on the issue of contempt for the judicial process itself.
Though contempt citations in the People's Court were limited by the nature of the binding arbitration framework, as it was not a true statutory court, Wapner wielded the moral authority of the bench like a scalpel. He made it piercingly clear that the defendants' attitude had compromised their credibility to an irreversible degree. He reviewed, line by painstaking line, the defendants' testimony and the evidence they had presented, but now viewed through the chilling filter of their declared belief in their own supremacy. Every technical argument, every piece of documentary evidence offered by the defendant was subjected to a newfound, intense skepticism. Wapner paused frequently, reading directly from transcripts or documents, only to stop and look over the top of his glasses at the defendant, asking rhetorical questions that underscored the lack of good faith inherent in their presentation. If the defendant truly believed the court was subservient to their family interests, Wapner interrogated, why should the court assume that any evidence presented was truthful, rather than simply fabricated or manipulated to achieve a predetermined outcome beneficial to the family? The implication was severe. The defendant's hubris had not just insulted the judge, it had potentially invalidated the entirety of their case on grounds of tainted testimony. The tension in the room became almost unbearable. The camera operators, instinctively realizing they were witnessing a watershed moment in the program's history, zoomed in tight on Wapner's face, catching the hard set of his jaw and the cold clarity in his eyes. The audience members, initially restless, were now perfectly silent, leaning forward, sensing the gravity of the pending judicial action.
This was no longer a trivial disagreement over a small sum of money. It had become a high-stakes confrontation between institutional authority and entrenched societal privilege. Wapner meticulously detailed the legal concept of clean hands, suggesting that a litigant who enters the court with such a fundamentally corrupted perspective, believing the system is rigged in their favor, cannot truly seek equitable relief. While this concept usually applies more strictly to chancery or equity courts, Wapner applied the moral weight of the concept to the arbitration setting, transforming the televised proceeding into a profound ethical lecture. He was establishing a record, both judicial and public, that the defendant's attitude was not only unbecoming, but legally prejudicial to their own position. He addressed the cost of judicial power, not the financial cost, but the cost in societal trust and painstaking precedent.
Wapner's monologue was exhaustive, traversing legal philosophy and practical court management. He explained that a judge's primary responsibility is not to find a happy medium or split the baby, but to uphold the law without fear or favor. And in this instance, delivering justice required first addressing the fundamental challenge to the court's authority. To ignore the defendant's statement would be to tacitly validate it, setting a perilous precedent that wealth dictates justice. The plaintiff, witnessing this meticulous dismantling of their opponent's credibility, began to show signs of hope, yet still remained profoundly apprehensive. The sheer density of Wapner's legal reasoning, layered one concept upon the next, was designed to convey the immense seriousness of the transgression. Wapner was constructing an unassailable legal justification for the severe ruling he was about to deliver.
He was not acting rashly. He was engaging in a judicial exercise of overwhelming force, ensuring that the coldness of his ultimate verdict would be understood as the necessary defense of the judiciary itself. Wapner finally returned to the core facts of the initial claim, but only after ensuring that the moral and legal landscape was entirely rearranged. The defendant's evidence, previously questionable, was now rendered fundamentally untrustworthy. The plaintiff's testimony, previously needing corroboration, now carried the weight of the only believable narrative in the room, simply because they had not insulted the court. The scales of justice, Wapner implied, had been violently tipped by the defendant's arrogance, and his task now was not merely to rebalance them, but to apply the maximum pressure necessary to correct the profound ethical imbalance that had been created. The court was teetering on the edge of the final pronouncement. Wapner had built his case, brick by agonizing brick, demonstrating that the defendant's wealth was irrelevant, that their family name afforded them no special immunity, and that their belief in their own control over the legal system was a catastrophic delusion. The stage was set for the delivery of the judgment, which promised to be less about the minor financial sum originally disputed and everything about the supreme power of judicial independence. Wapner looked one last time at the defendant, the patience finally drained from his expression, replaced by a deep, immovable resolve that signaled the end of the legal argument and the beginning of the inevitable reckoning. The entire legal framework had been insulted, and Judge Joseph Wapner was preparing to issue a reply that would echo far beyond the confines of the television studio. The moment of silent confrontation extended, heavy and suffocating, over the small claims courtroom.
The ambient noise of shuffling papers and whispered consultations ceased entirely, replaced by an acoustic vacuum where only the faint, rhythmic ticking of a clock high on the wall asserted the relentless march of time. The single, profoundly entitled utterance, "You work for my family," had acted as a surgical strike against the foundational tenets of American jurisprudence, assaulting the concept of equality under the law. And Judge Joseph Wapner, having absorbed the full impact, began his meticulous, devastating dissection. This was the crescendo of entitlement meeting the hard wall of judicial authority. The defendant, previously exhibiting a posture of casual dismissal, now recognized the gravity of the shift, attempting to retract the implication with hurried, nervous gesticulations toward their counsel. But the words were out, recorded, and irrevocably lodged in the record.
Wapner, leaning back slightly, his customary patience shed like a worn garment, focused his gaze not on the counsel, but directly on the source of the insolence, a wealthy scion whose worldview had just been revealed as dangerously skewed. The initial financial dispute, centering on $18,500 owed for specialized design and construction work, now seemed almost secondary. The true conflict had transmuted into a battle for professional dignity and the preservation of the court's neutral jurisdiction. Wapner started not with the final dollar amount, but with a precise, almost clinical review of the evidence already presented, establishing a rock-solid foundation for the ruling that was about to shatter the defendant's perception of reality.
He meticulously recounted the chronology of the contract, the initial agreed scope, the executed work orders, the successful completion certificate signed by the defendant's estate manager, and the subsequent intentional delay in remittance. He detailed the correspondence, noting the plaintiff's professional attempts to resolve the outstanding balance, juxtaposed against the defendant's consistently vague and condescending replies. Every point established the plaintiff's competence and due diligence, simultaneously painting the defendant's actions as deliberately obstructive and rooted in a desire to leverage social standing for financial advantage. The evidence before this court, Wapner began, his voice lowered but carrying an undeniable weight that compelled absolute attention, clearly demonstrates a debt owed. The plaintiff performed the agreed-upon services competently, timely, and to the specifications previously approved by the defendant's agents.
However, the counterclaims alleging superficial defects introduced only after the filing of this suit are deemed spurious and unsupported by contemporaneous documentation or expert testimony. With surgical precision, Wapner dismissed the defense's attempts to introduce irrelevant procedural complexities, shutting down the counsel's frantic attempts to pivot the narrative toward contractual ambiguities. The judge's focus remained laser-sharp. The contract was valid, the work was finished, and payment was willfully withheld. This rigorous establishment of the facts was merely the preamble. The crucial moment arrived when Wapner transitioned from discussing financial damages to addressing punitive conduct. The open loop concerning the ultimate cost of the defendant's arrogance was about to be closed with brutal finality. However, Wapner continued, pausing to let the weight of the words settle, this case has moved beyond a simple breach of contract.
We are compelled to consider the element of professional degradation and the clear, deliberate attempt to exert undue, non-contractual control over the plaintiff. He addressed the defendant directly, fixing him with a stare that brooked no deflection. The statement made to this court that the plaintiff works for my family is profoundly instructive. It is not merely an opinion. It is a declaration of a perceived master-servant relationship, where one party believes the other exists solely at their capricious discretion, extending far beyond the scope of a commercial engagement. Wapner articulated the judicial interpretation of the offending phrase. It was an attempt to negate the plaintiff's professional autonomy and deny the equality of standing that defines a contractual agreement in a free market. It was an insult directed not just at the plaintiff, but at the very system designed to protect them. This court finds that the defendant harbored a malicious intent to leverage their superior financial position to intimidate and diminish the plaintiff, thereby attempting to compel performance or acceptance of non-payment through sheer social pressure. This constitutes behavior that the judiciary must forcefully discourage, particularly in forms designed for the impartial resolution of disputes between parties of vastly unequal means. The development phase climaxed with the announcement of the initial judgment. Wapner affirmed the full principal amount immediately. Judgment is hereby entered for the plaintiff in the amount of $18,500, representing the outstanding contractual balance. The courtroom held its breath, knowing the hammer had yet to fall. The $18,500 was the expected award. The extraordinary element was the punitive dimension.
Wapner then meticulously detailed the legal justification for stepping outside the usual parameters of small claims judgments, citing precedents concerning willful misconduct and the necessity of deterrence against wealthy litigants who utilize the legal process as a tool of oppression. He introduced the concept of exemplary damages, designed not to compensate the plaintiff for tangible loss, but to punish the defendant for their conduct and serve as a warning to others. Due to the egregious nature of the defendant's conduct, his demonstrated contempt for the plaintiff's professional standing, and the calculated attempt to bypass the jurisdiction of this court by asserting a form of personal feudalism, Wapner stated, his voice now steel-cold, "This court finds punitive damages are warranted." He paused again, ensuring maximum impact. The defendant, realizing the severity of the situation, had visibly paled, his previous bravado entirely evaporated.
His counsel leaned toward him, whispering frantically, undoubtedly urging him to remain silent, a plea that was decades too late. Wapner then delivered the judgment that would etch this case permanently into the annals of the program's history. In quantifying the professional and emotional damage inflicted by the prolonged dispute and the deliberate disrespect shown to the plaintiff's dignity, this court awards an additional sum reflecting the willful nature of the malice. Considering the established financial means of the defendant, the only amount sufficient to serve as a meaningful deterrent rather than a mere annoyance is warranted. The judge proceeded to systematically stack the financial penalties. First, he added interest accruing from the date of the agreed payment, calculated at the maximum statutory rate, a precise figure that added several $1,000s to the total. Second, he included the full cost of the plaintiff's professional legal preparation, normally limited in small claims, but permitted here due to the defendant's proven recalcitrance. Third, and most devastatingly, Wapner levied the punitive damages. For the deliberate attempt to diminish the plaintiff's autonomy and profession, and for treating the sanctity of contract as a negotiable privilege determined by wealth, this court imposes an additional $35,000 in punitive damages. The combined total, exceeding $53,000, landed with the force of a physical blow. The figure was astronomical for the format, a direct response to the defendant's perceived immunity. It was the absolute maximum assertion of judicial power in that specific venue. The cost of those 6 arrogant words had just been calculated, and the price was astronomical. The defendant gasped audibly, a sound instantly stifled by his counsel, who merely slumped forward, recognizing the complete and utter defeat. The realization was immediate. The defendant's flippant sense of superiority had cost him 3 times the initial debt, ensuring that the penalty was painful enough to necessitate a fundamental reassessment of his behavior. Wapner closed the loop on the contempt shown to the institution itself. He emphasized that the ruling was not merely about restitution, but about upholding the integrity of the judicial process. The function of this court is to ensure equity, not to enforce the social hierarchy desired by wealthy litigants. When a party attempts to intimidate or demean an opponent based solely on their economic status, they commit an offense against the principle of justice itself.
The damages assessed reflect the necessity of maintaining a level playing field where a contract is a binding agreement between equals, regardless of the size of their bank accounts or the lineage of their families. He granted the plaintiff the full, decisive victory. The plaintiff, who had endured months of non-payment and professional insults, visibly trembled, not with fear, but with the shock of vindication. It was the realization that the law, when executed by an uncompromising jurist, truly could stand against unchecked privilege. The gavel finally fell, a resonant final punctuation mark that echoed through the stunned courtroom. It was the sound of the case being permanently sealed, the sound of the door slamming shut on the defendant's expectation of special treatment. The conclusion of the hearing was swift. Wapner gave no further opportunity for appeal or argument on the matter of the damages. The ruling was final, delivered with a coldness born of absolute necessity.
The defendant learned, in the most financially painful manner imaginable, that no amount of family wealth or social standing could insulate him from the consequences of contemptuous arrogance when facing a judge dedicated to the impartial application of the rule of law. The episode became legend, a powerful, visceral demonstration to millions of viewers that the court was not a stage for social theater, but a serious mechanism for justice. It underscored the fundamental truth that equality under the law is not a polite fiction, but a fiercely guarded reality, and that when a litigant seeks to diminish the professional dignity of another, especially when wielding the weapon of class superiority, the penalty will be swift, severe, and absolutely uncompromising.
The ultimate payoff was not merely the large judgment for the plaintiff, but the resounding clarity of Judge Wapner's message. Disrespect for the professional standing of an honest worker, and by extension, disrespect for the judicial process itself, would be met with the coldest, most financially punishing ruling the court could render. It was a victory for the principle over the pocketbook, a definitive rebuke to entitlement, delivered with the absolute chilling precision of a zero-tolerance policy. This landmark decision ensured that the memory of those 6 words would forever serve as a cautionary tale. In Judge Wapner's courtroom, everyone, from the most humble contractor to the wealthiest scion, stood precisely equal. The legacy of this ruling remains a touchstone in legal education and public fascination. It serves as an enduring reminder that the judicial system is the final, essential check against the excesses of power and privilege. The swift, total annihilation of the defendant's case, triggered by that singular, arrogant sentence, reinforced the crucial notion that true justice often requires the application of force proportionate not just to the monetary debt, but to the ethical violation, a force Judge Joseph Wapner deployed with devastating and unforgettable effect. This case stands as a testament to the court's unwavering commitment to dignity and fairness, demanding that all parties recognize the mutual respect inherent in a commercial society, and enforcing that demand with the most severe penalty possible. It cemented the judge's reputation not just as an arbiter, but as a fearless defender of the working professional against the casual tyranny of wealth.